Miscellaneous provisions of valid contract. In addition to the requirements of Section 2H, which defines the term contract, and Section 10, which lays down for more conditions of validity or enforceability, law further requires the fulfillment of two miscellaneous provisions. They are: number one, contract may be express or implied. The term express means which is explained by words, spoken or written. From this explanation, we come to know that oral agreement is as good as written agreement is. Sometimes students raise a question: why not every agreement should be in writing? The answer to this query is that it is not possible or it is inconvenient so far as business world is concerned that every agreement must be in writing. Let us have an example. Suppose you go to a shopkeeper and intend to buy one cold drink. Would you like to firstly make an offer to him in writing that you intend to buy one cold drink? Then he should answer you in writing. Then again you should place an order and he should supply. So it will waste time and energy so far as business transactions are concerned. Therefore, most of the agreements which are of daily routine type, they are orally entered into. However, our law requires that some agreements must be in writing. It means oral agreement will not be enforced by law courts. For example, hire purchase agreements, they must be in writing. Law further requires that some of the written agreements must also fulfill certain other technical formalities relating to attestation, affixing of stamps, signatures of witnesses, signatures of guarantors, registration of the document, etc. For example, when we intend to borrow money from a bank, we enter into loan agreement. So in that case, it must be in writing, there must be signatures of witnesses, it must be on a stamp paper, there must be signatures of guarantors as well. The term implied means which can be known from the conduct of the parties. Simple examples are when we board a bus, or telephone machines, or weighing machines. They offer by their conduct to take you from one place to another. When you board a bus, impliedly you are given your acceptance. So it is a case of implied contract. When contract can be expressed, it can be implied. We must keep in mind that based on it, offer can be expressed, offer can be implied. Acceptance can be expressed, acceptance can be implied. Agreement can be expressed, agreement can be implied, and hence contract can be expressed and contract may be implied. The second miscellaneous element in valid contract is that subject matter must be capable of performance. It should not be impossible. In this context, Section 56 of the Act states that an act which is impossible in itself is void. For example, A agrees with B that he will run at the speed of 1000 miles per hour. It is thus not possible. A will bring life in B's dead body with the help of magic. It is just not possible. So far as this Section 56 is concerned, we must know it in some more detail. Section 56 has three parts. One part is, which we are just referring to, that an agreement which is impossible in itself is void. The other part is that if one of the parties is aware of the impossible nature of a contract and that party knows the other party is not aware of, then if that party does not reveal that fact, contract becomes void and not enforceable. Now suppose A's ship has already sunk and he enters into contract for the sale of the same ship to B. It is void agreement. Likewise, there may be subsequent impossibility, which we will just refer to. It is at the time of formation of a contract, it fulfilled all essentials, but due to some supervening impossibility, which was beyond the control of the promisor to overcome, contract becomes impossible to perform. That is subsequent impossibility, thereto contract becomes void. Suppose A has agreed to sell his building to B. Unknown to both of them, the building had already collapsed. Then it is impossible to fulfill the contract. Now, after referring to these essentials of a valid contract, while dividing into three portions, the definition, section 10 and miscellaneous points, we would like to know what are the consequences if all the elements are not present in a contract. If all the elements are present, then contract is valid and enforceable. If any of the elements is not present, so our answer will be that contract is void, but not. This answer is not correct. When any of the elements is not present, then consequences are different. Say for instance, if free consent is absent, the effect is that contract is voidable. If capacity to contract is absent, agreement is void. If consideration is absent, agreement is void. If there is some technical error relating to attestation, etc., then consequences are that contract is unenforceable. Now, based on these consequences, now we have classification based on enforceability. We have various types of classifications based on enforceability. First three are based on the results if one of the elements is not present. One is voidable contract. The voidable contract, very important term so far as our examinations are concerned. Voidable contract is one which may be avoided at the option of one of the parties and not at the option of the other party. There is only one of them can cancel the contract if that party so opts. The party who can avoid it, who has this right or option, is known as an aggrieved party, the sufferer. Aggrieved party is he whose consent is not free. So usually when consent is obtained by coercion, undue influence, misrepresentation or fraud, then contract becomes voidable. We must keep in mind that voidable contract also results in certain other situations as well. Now, what are the conditions of avoiding the contract? If aggrieved party, now the question is who's aggrieved party? Offerer or the acceptor? Our answer is certainly the acceptor, because offerer has used tactics to induce the acceptor to give his consent. Therefore, aggrieved party, or also known as a plaintiff, is always the acceptor who has given his consent by one of the foul methods used by the offerer. The conditions for avoiding the contract. Contract must be avoided within a reasonable period of time. Now the term reasonable period has not been defined. Therefore, it depends upon the facts of each case, and the court is alone empowered to decide whether reasonable period is over or not. And second condition is that this contract must be avoided before third parties' rights intervene. Suppose third parties have right intervene, that is, he has become the purchaser and he happens to be innocent buyer who is not aware of this fact that he is buying the goods from a seller who is having the possession under a voidable contract, he has relied on him, he has paid the price, then third party's right will intervene, and now the agreed party will not be in a position to cancel the contract. Thirdly, in this case, when the voidable contract is avoided, principle of restitution applies. It also applies in so many other cases. It means what? It means when the party who has avoided the contract, certainly he will get back his goods. Now he will have to restore back the benefit received, benefit or consideration or price, so that both the parties come on the same footing as if there was no contract entered into between them. One thing more must be kept in mind in this context, that is, it is a voidable contract. It will remain valid until the aggrieved party exercises his option and treats it as cancelled. Next one is void agreement. Void agreement is opposite to valid contract. Void agreement means an agreement which is not enforceable by law. It is void ab initio. It has no meaning so far as law is concerned, right from the very beginning. Say, for instance, agreement with a minor. The third one is unenforceable contract. That is also from the technical errors. When there is a technical error, though the contract was valid in itself, but court will not attend to it because of that technical error. However, if that technical error can be removed, then unenforceable contract will become enforceable one. There are two more types of contracts which are mentioned in the classification of contracts from the point of view of enforceability. These three have resulted from the consequences when one of the elements is absent. They result from certain other portions of the law. One is void contract. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. What does it mean? In simple words, it means that at the time of formation of a contract, it was a valid one. Due to certain reasons beyond the control of the promisor, it is not possible to perform it. Therefore, it ceases to be enforceable. For example, we have just referred to the third type of impossibility under section 56. It is known as subsequent impossibility of performance. Suppose A has, I am repeating the same example, A has agreed to sell his building to B. Now, before that date, due to lightning, which was not under his control to overcome, the building collapses. Now it is not possible for him to sell the building. Likewise, if A has agreed to sell certain quantity of rice to B, but before due date, government passes an order whereby sale of rice is prohibited by private individuals. Now, this is subsequent impossibility and the contract is not possible to be performed. It ceases to be enforceable, therefore it becomes a void contract. And lastly, illegal agreements or unenforceable agreements. Now, this term has been explained in an indirect manner under section 23. We have said under section 10 that object or consideration of an agreement must be lawful. What is not lawful has been explained under section 23. An agreement is illegal if its object or consideration is, number one, forbidden by law. There are certain acts which law does not permit. Two, if it is of such a nature that if permitted, it will defeat the provisions of any other law. So what does it mean? It means what what is directly prohibited under number 1 is also indirectly prohibited as well. Let us have an example. A has not paid certain taxes to the government. Government intends to sell his property by way of auction so as to realize the revenue. Now suppose the rules are that defaulter cannot himself take part in the auction sale. And generally these are the rules. Now what the owner of the property does, he enters into an agreement with his friend requesting him to buy the property on my behalf through an auction, then sell it to me. If this type of agreement is validated, then it will defeat the provisions of first law, whereby it is forbidden by law not to do that act. Therefore, what is directly prohibited is also indirectly prohibited. Third one is if it is fraudulent. So if object is with the intent to defraud others, then it is not a valid one, it is illegal one. For example, two friends are pickpocketers. They enter into an arrangement or agreement that any one of them who picks pocket of another and gets money, he will have to pay 50% to the other. One of the friends pickpockets and gets 1000 rupees. He doesn't pay 500 rupees to his co-fellow. Can other friend go to the court and file a suit against him for recovery of his share? Certainly not, because it is with the intent to deceive others. Fourthly, if it involves or implies injury to a person or to the property of another, then too it is not valid one. Object is unlawful, it is illegal agreement. Let us have a simple example. A gives a loan to B worth rupees 10,000 at market rate of interest. A also requires B to come daily to his house and do the gardening work, for which he will not be paid at all. It is injury to a person or to the property. For instance, suppose A requires B, a printer, to print libels. Libels means which will defame a person. To print libels against a particular person or a leader. He fears defamation case, but the printer says to him that if suit is filed against you and you suffer a loss, I will compensate you. So he prints that libels defaming another person. That another person files a suit for defamation and wins with 1 crore rupees. Can he claim it from the promisor? Our answer is no, because here it involves injury to a person or to the property. Lastly, if the court regards it, it means object or consideration. If the court regards it as immoral or opposed to public policy. So, this fifth point is left to the discretion of the court. If court regards it as immoral or opposed to public policy. Now, these two words or concepts have been disassociated with each other. Why it is so? Because immoral act is always against the public policy. But public policy may not be always illegal. Let us have an example for immoral act. Suppose A gives his house on a rental basis to a prostitute. Can he claim rent from her? Our answer is no, because it is an immoral activity. Let us dwell on public policy. Now, the term public policy has not been defined in the Act. Therefore, in a democratic setup of a country, the term public policy means that policy which is made by the government, which is in the interests of larger section of the society. Therefore, this term is subject to exact definition. There cannot be any definition of it because it goes on changing from government to government, same government from time to time, depends upon the requirements of the situation. However, certain heads have been defined whereby we can say these acts are against public policy. For example, trading with alien enemy. So alien, the partner, may be our friend. We can have trade connections with him or with that country. But when our relations become hostile, then it is against public policy to help the other country which is not on good relations with us. Likewise, trafficking in public offices. Now, when a person pays certain money to another, requiring him not to join a particular job so that his turn comes, it is against the public policy. Interfering in the administration of justice. The rule is guilty must be punished. Therefore, against this rule, if there is an agreement whereby some dispute is to be suppressed, then that is against the public policy. Truth must come out. Likewise, agreement interfering with the parental duties. The parents are our guardians. This guardianship cannot be alienated or transferred on a permanent basis. Agreements relating to marriage brokerage. Marriage brokerage agreements are also against public policy. So these are some of the examples of public policy. Thank you, viewers.